Hello, this is Allison Eicher, and I will be your librarian for the research component of RWA. This class will be different from the other sections in a couple of ways. First, there will be a contracts focus, just like in Professor Lawton's RWA course. Second, this will be taught in a semi-flipped format. That is, you will listen to lectures before class, and then we will work through practice exercises and homework in class. This format has been well received the last few times I've taught it this way. This results in you spending less time outside of class working on research assignments and more time working on your other courses. This doesn't mean that what I'm here to tell you is not important. I expect you to come to class prepared by having listened to the lectures. There will be short quizzes at the beginning of each class that will be graded. They will be simple, but will be based on materials covered in the lectures. At our first face-to-face meeting, we will cover the syllabus, the assignments, and grading in more detail. I want you to know that one of my goals is to create a classroom atmosphere that encourages open dialogue, lots of questions, and a relaxed atmosphere. I will not use the Socratic method, but I do expect you to participate in class. If I don't have participants, I'm going to have to call on random students. This format requires active participants in order to work. If you have any questions or concerns, please don't hesitate to contact me before class. My email address is listed here, as well as my office number. My office seems to be in a hidden location, but if you ask for Allison Eicher at the circulation desk, they will direct you to my location. Also, don't be afraid to stop by the reference desk to say hello. The purpose of the research component of RWA is to expose you to actual legal research problems. Legal research is so much more important than one might think. Mastery of the tools at your disposal will make you a more efficient attorney. It is critical not to disregard the importance of legal research. In the practice of law, the stakes are high. Shortcuts and incompetence could cost you your reputation, money, and even your license to practice. And you don't get a discharge on that student loan money if you get disbarred. This is the legal research bullseye and shows you all of the resources that are available to you, the legal researcher. Some look at this as a sort of roadmap. You start in the outer ring with secondary sources. The information you find in those sources will lead you to primary sources in the second ring. Once you've reviewed primary sources, you may end up back in secondary sources for more understanding or redirection. Finally, you will update and verify that the primary source you found is still good law. That is, does it still apply or has it been overruled or repealed? You will hear stories of the ill-prepared attorney who showed up in court without updating their research or shepherdizing their case, only to be shot down by opposing counsel, or even worse, a judge who knows that the case was overruled. It's easy to forget to update your research, but a final check the day before submitting a brief or showing up to court is well worth it. There are two types of legal authority, primary and secondary. Primary authority is going to include constitutions, both federal and state, statutes and regulations, and case law. The authority we are going to be talking about in this lecture and in our first class session is secondary authority. That is, everything that is not primary authority. The chart on this slide may serve as a helpful tool as we progress through the research component. It reminds you what is binding, that is, what you must obey, and what is merely persuasive. You need a plan, a legal research strategy. You should always start your research with a plan, and you should always keep track of where you've been so that you don't end up doing duplicative work. I'm going to talk a little bit about planning over the next couple of slides, and you'll find me revisiting this point throughout the component. When I start any research project or problem, I reword the question presented. At the very least, I write the question down. This can help you identify search terms. Identifying search terms can be difficult, especially when you're new to the law. Once you're more familiar with legal terms and concepts, you may still encounter difficulties when you're researching a new area of the law. Moving on, you'll then identify secondary sources. Now, it's important at this stage to figure out a few things. What's your jurisdiction? Are you in state or federal court? These are important to direct you to which types of secondary sources and then primary sources you're going to be looking for. We're going to talk about the different types of secondary sources today and in class, but they should be your starting place. I'll give you some examples in class. For now, though, understand that secondary sources will inform your search for primary sources and will also help you develop that list of search terms. At this point, you may want to refine your search terms and identify new questions. Then, you'll identify your primary sources and use your search terms to locate primary authority for your question. Finally, you'll assess your results. Did you find your answer, or did you end up with more questions? There is no process written in stone for how to complete legal research. There are many suggestions, though. You will develop your own way of doing things, though, as you become more familiar with the law and resources. It may also depend on the database that you're using. That is, wherever you end up practicing, you probably won't have Westlaw, Lexis, and Bloomberg Law at your disposal. You may have one or none. The tools I'm looking to teach you, though, will help you no matter what you end up with, even if you end up with a dreaded print resource. Until you work out your own process, though, these are 3 basic steps that you can follow. Start with secondary to familiarize yourself with the topic, then research the primary authority that you learned about from the secondary sources. Finally, verify and update to make sure what you found is still good law and applies to your scenario. The law is very fact-specific. The difference in one seemingly minor fact can and will change the outcome of a case. The presence or absence of one seemingly minor provision in a contract could make or break your client. So it's important to recognize relevant facts in order to conduct your research and to be an effective practitioner. Searching through electronic resources efficiently is a skill that can be honed. The major legal research databases, Lexis, Westlaw, and Bloomberg Law, all use natural language searches as their default. You're probably accustomed to this way of searching now. You simply type in what you're thinking of or looking for. There's another method of using search terms, and that is called a terms and connector search, or using Boolean operators. So instead of typing in that you're looking to find out if it's legal to operate a motor scooter while drinking, you would use a combination of terms and some operators that show the relationship between those terms. I've included a video on the TWEN page that describes how Boolean operators function. When I learned how to do legal research, this was the only option. Natural language searches were not an option. Each database has differing operators, but there is usually a key readily available. Learning to use these operators can be more efficient and yield more relevant results than a natural language search. Secondary sources can provide the foundation upon which you build your legal research. Secondary sources can do all that I've listed, but can also expand your overall knowledge of the law. I quote from Osbeck's Impeccable Research, First Edition. The other somewhat hidden benefit to regularly using secondary sources to acquire background information at the beginning of your research is that, in the long run, the practice makes you a more knowledgeable lawyer. Why? Because when you try to actually learn something about the topics you're researching, instead of just finding the answers to narrow questions you were assigned, over time you begin to weave together an understanding of the law as a whole that continues to grow the longer you practice and the more you learn about individual topics. This gestalt view of the law will serve you well as you transition from a beginning lawyer who researches specific legal problems to a seasoned counselor whose sage advice clients actively seek out. This slide really explains itself. There will be times, like when you have become very familiar with an area of the law, that you may not need to go right to a secondary source. However, just starting out in legal research and the law, secondary sources can be invaluable. Please keep in mind that there are ways you should not use secondary sources. You will almost never cite secondary sources to courts, only in very rare circumstances. Use the secondary sources to lead you to primary authority, which you will then review for yourself and cite. I'm going to talk briefly about the types of secondary sources available. Our in-class work will illustrate the use of the most commonly used resources. When you don't know what a word means, you know to look it up in the dictionary. Well, there are dictionaries specific to the law. So if you want to know what a word means in the legal sense, you consult a legal dictionary. Examples are Black's Law Dictionary and Ballantyne's. Both are available electronically and in print. Black's Law Dictionary is probably the most commonly consulted, though. Think back to grade school and writing a small research paper. You probably used an encyclopedia. Well, we have them in the law, and they can be immensely helpful in helping you understand the law. Examples are shown above. It's helpful to know that these can be available for specific jurisdictions as well. For example, Michigan has a legal encyclopedia entitled Michigan Law and Practice. American Law Reports. Each semester I struggle to differentiate for students the difference between American Law Reports and legal encyclopedias. That is, they're so similar to me that I feel strange making a differentiation. However, American Law Reports, or ALRs as they're commonly referred to, are meant to provide information on unsettled areas of law. That is, areas of the law where circuit splits may exist. So perhaps the Sixth Circuit has decided that you can shoot your neighbor without cause, and the Ninth Circuit has decided that you can't. You're in the Third Circuit, and the Third Circuit hasn't weighed in yet on this issue. You could go to the ALR on the topic and use the resources contained therein to find explanations and primary authority to help draft a persuasive argument either way. Basically, ALRs are similar to encyclopedias in that they cover a range of topics. They differ in that they delve deep into the topics they provide and give a summary of the law rather than an analysis. Students commonly confuse treatises with treaties. Treaties are agreements between countries. Treatises, on the other hand, can be a very valuable secondary source. Treatises can provide historical information about a topic as well as current awareness. They sometimes serve as a be-all, end-all, and will lead you to primary authority. If you're researching contract law, you may want to look at Williston on Contracts or Farnsworth. I've provided a link on Twen that will take you to contracts resources assembled by Georgetown Law. MSU also has these resources if you're interested in looking at them. The restatements are a secondary source that can carry some weight. Published by the American Law Institute, the restatements attempt to summarize the common law in the majority of United States jurisdictions. The ALI will also indicate new or growing areas of the law and even make proposals where the Institute thinks change may be needed. These restatements are written by highly respected scholars and are only adopted after a rigorous drafting and review process. It's important to keep in mind, though, that although courts may adopt a restatement's rule, the restatement itself is still secondary authority. Uniform laws and model acts can be a bit confusing. You will hear a lot about them in your classes. Think contracts and the Uniform Commercial Code. Note that these are uniform acts. They are recommendations, and it is up to individual legislatures to adopt these for their jurisdictions. These are secondary authority because they are not the actual law. If you wish to cite the primary law, you need to go to your jurisdiction and find where the uniform law has been adopted and cite to that jurisdiction's law. The uniform law can be persuasive, though, and the information related to the development of the law can provide good information in understanding the law and its purpose. Legal periodicals or law journals are great sources of information. They can provide long historical analysis or discussions of up-and-coming changes in the law. For practical purposes, law reviews may not be all that helpful. And what I mean by this is that if you are in practice and you're trying to figure out how to handle a situation, a law review article may not be the best place to go. However, if your local bar or special interest section has a journal, they may have articles with more practical information. Legal periodical indexes are merely tools one can use to locate law review and bar journal articles. We will work with one in one of our assignments. When I start my search for scholarly works, I start with an index as opposed to Lexis or Westlaw because the index searches more databases. You will need to use the library catalog in your homework. The catalog provides you with a way to search through everything, print and electronic, that the MSU libraries hold. It will be an invaluable tool when you write your upper-level writing requirement or if you end up on one of the law reviews. There are other resources that I believe get forgotten in beginner legal research courses, and I think they can be quite valuable. Those resources are practice resources and basically provide you with the information you need in order to do something. So if you need to know how to file a motion for summary judgment, there are resources out there that will tell you what forms you need to use, what you need to consider, and what to do once you've completed the forms. From Michigan, the Institute of Continuing Legal Education, or ICLE, provides great resources. Wherever you end up practicing, you should ask to find out if there is a publisher of practice resources. Your state bar may be of help as well. So to briefly recap, secondary sources provide you helpful analysis that will guide your understanding of the law. Secondary sources can help you master the vocabulary or learn the terms of art. Secondary sources can also lead you to primary sources, which you can then cite. These sources may also lead you to other secondary sources which provide additional information and education. These are just some points to remember throughout the research process. You will develop your own process as you learn more about the law and become more familiar with resources. Just let these be a guide when you feel you may have lost your way. We've come to the end of our first lecture. I like this quote, and it is something I always keep in mind when I'm writing. If you have any questions, please contact me. I'll see you in class.